A patent filed today faces different legal risks in Munich than it does in Paris. A generative AI model trained in California triggers massive regulatory compliance audits the moment it operates in Europe. The assumption that technology can be deployed under a unified global framework no longer applies. The international standard has fractured. Compliance now depends on navigating distinct regional regimes and highly specific local enforcement conditions. By 2026, three specific variables dictate the survival of a technology portfolio: sweeping macroeconomic shifts in filing volumes, highly localized litigation in European courts, and rigid regulations governing artificial intelligence. A patent document's internal claims are no longer enough to determine its valuation. Sustaining a technology portfolio in 2026 requires accounting for these variables, jurisdictional arbitrage, and data provenance, to accurately assess risk across the global market. To map this fragmentation, we first look at the macroeconomic baseline established by the World Intellectual Property Indicators. The geographic center of gravity for global innovation has migrated. This bar chart visualizes the volume of patent applications currently being processed by China. At 1.8 million filings, it is more than 3 times the volume submitted to the United States Patent and Trademark Office. That concentration of prior art is compounding as India's intellectual property ecosystem expands alongside it. Adding India's data reveals a 19.75% year-over-year growth rate, pushing total applications to nearly 750,000. Crucially, 61.79% are domestic filings. This surge is directly supported by capacity-building programs, like the induction of 400 new patent examiners and the integration of AI-powered search tools to clear application backlogs. The sheer weight of these filings carries massive geopolitical implications. The overwhelming majority of the world's new prior art is now generated and documented in Asian markets. Developing nations are leveraging this density to transition from policy takers to policy makers on the global stage. We see this exact dynamic in the recent World Intellectual Property Organization Treaty on Genetic Resources and Associated Traditional Knowledge, the first IP treaty explicitly proposed and driven by developing countries. Because the volume of innovation is heavily concentrated in the East, multinational IP strategy must pivot to account for where the art actually lives. As filing volumes shift eastward, the nature of the assets being protected is changing. Generative AI systems rely on the mass ingestion of existing information, turning training data into a high-stakes liability. The enforcement of the 2026 European Union AI Act acts as the catalyst for the data enclosure era. Under this act, providers of general-purpose AI models are required to publish a detailed public summary of the specific datasets used for their training. Developers must build programmatic checkpoints to verify whether a data source has reserved its rights under the EU Copyright Directive, and they must clearly label any AI-generated outputs. Failing these compliance checks triggers severe financial penalties, reaching up to 10 million euros or 2% of global annual turnover. Simultaneously, a parallel legal battleground is playing out in the United States. Here, courts are testing the tension between the mass ingestion of copyrighted text and the strict requirements of the 4-factor fair use test. High-profile media lawsuits, including actions brought by the New York Times against OpenAI and Microsoft, are actively challenging the legality of this unlicensed ingestion pipeline. Liability extends to the output side of the pipeline as well. The U.S. Copyright Office enforces strict human authorship requirements. Courts have repeatedly affirmed the legal precedent that AI-generated outputs lacking meaningful human creativity are ineligible for copyright protection. In 2026, AI training pipelines must treat data as a licensed, strictly audited asset. Mass data ingestion now requires the same oversight as a high-stakes financial audit. This regional divergence extends beyond AI compliance and directly into patent enforcement, particularly within the Unified Patent Court. 2 years of merits decisions reveal that the theoretical promise of a single unified European court masks a highly fragmented statistical reality. This chart shows the aggregate patentee win rate across the UPC, sitting at 54.2%. But breaking this data down by local division reveals a stark contrast. The win rate jumps to 71.4% in Munich, while dropping to just 33.4% in Paris. There are severe hidden risks embedded within the dockets of both Paris and Mannheim. In those specific divisions, Every single patentee loss resulted in the complete revocation of the patent, rather than a simple finding of non-infringement. Sophisticated forum selection also relies on a secondary metric, adjudication speed. The Hague has established a specific capability for speed, delivering preliminary injunctions in a median time of just 91 days. Conversely, Paris offers the fastest path to a full merits decision, forcing plaintiffs to weigh that speed against the documented risk of total revocation. Under the UPC framework, tactical forum selection is the single most critical maneuver in European patent enforcement. You have to actively balance the need for speed against the statistical threat of losing the patent entirely. Multinational enterprises are now managing assets across fractured regional legal systems. The unified approach has been replaced by a set of localized rules. The United States landscape is defined by high legislative uncertainty and foundational fair use battles over training data. The European landscape demands exact algorithmic transparency while requiring aggressive forum optimization within the UPC. And the Asian landscape stands as the undeniable center of gravity for prior art and sheer innovation volume. Applying a monolithic strategy to this segmented environment will result in mispriced assets and severe legal exposure. A successful 2026 enterprise strategy requires treating compliance protocols, jurisdictional selection, and geographic density as interconnected variables to truly safeguard technological assets.